oversight. Give divine guidance to the President of the Republic. Endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people will be well and truly served, and their good purposes for the common human life be realized in our midst. Amen. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be with, a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people, and the love for the common good. Bless the efforts of those who struggle to make this vision a living reality. Inspire and strengthen our people, that in time, thought, and sacrifice, to speed the day of the coming beauty of Ghana and Africa. Amen. Honourable members, votes and proceedings, 17th December. Page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8, page 9, 10, 11, 12, yes, Honorable IP. 13, 14, 15, 16, 17, 18, 19, 20, page 21, page 22, 23, page 24, 25. Yes, Honorable Kujito Ablakwa.
Yes, Mr. Speaker. Right now, page 24, my honorable colleague's name has not been properly captured. Honorable Peter Nochu Kotwe. So if he can be about the education committee. Thank you.
25, 26, 27, 28, page 29, page 30, 31, 32, 33, page 34, page 35, 36, 37, 38, 39, page 40, page 41, 42, page 43, page 44, 45, and page 46. The votes and proceedings of Thursday, 17th December, as presented and corrected, is hereby admitted as true record of proceedings. Official report. We have a few of them. Dated 4th. Any corrections, please? In the absence of any corrections, the official report of 4th November hereby admitted as true record of proceedings. We also have 7th November in 4 volumes. November in 4 volumes. Honourable members, in the absence of any corrections, the official report of 7th November were admitted as true record of proceedings. Business statement for the 7th week. Honorable Majority Leader and Chairman of the Business Committee.
Mr. Speaker, thank you very much. The Business Committee met yesterday, Thursday, the 17th of December. What day is this? And the Committee Arranging Business of the House for 7th week ending Tuesday, the 22nd of December 2020. As I indicated, we have to interrogate this, whether this is a standalone meeting. If it is a standalone meeting, then it will be the second meeting of the fourth of the second week of the fourth meeting. Mr. Speaker, the committee accordingly submits its report as follows. You may read any available communication to the House. Right Honourable Speaker, pursuant to Order 72, ministers may be permitted to make statements of government policy. Statements duly admitted by you, Right Honourable Speaker, may be made in the House by honourable members in accordance with Order 72. Speaker, bills of urgent nature may be taken through the various stages in one day in accordance with Order 119 to Order 75. Papers for presentation to the House may be placed on the order paper for laying. Committee reports may also be presented to the House for consideration and possible adoption. Speaker, motions may be debated and their consequential resolutions, if any, taken during the week. Right Honourable Speaker, the House is scheduled to sit on Monday, the 20th of December 2020. Sittings of the House may also be extended beyond 2 p.m. as stipulated in Order 42. Speaker, let me emphasize that we're going to have extended sittings on Monday and possibly on Tuesday as well. This enables the completion of scheduled business for each day of the week under consideration. In view of the tall order of outstanding businesses which require consideration and approval, the Business Committee appeals to honourable members to exhibit the usual commitment and diligence to enable completion of same within the sitting of the week. The House is expected to break for the Yuletide day, the 22nd of December 2020. The House would reconvene, hopefully, on the 4th of January 2021 to wind up business of the 7th Parliament. Speaker, if we do reconvene on Monday, the 20th and the 4th of January, we anticipate to complete the business and adjourn on Tuesday, the 5th of January 2021, to await the proroguing of Parliament on midnight of 6th January. Speaker, in accordance with Standing Orders 160, sub 2 and subject to Standing Order 53, the committee submits to this Honourable House the order in which the business of the House shall be taken during the week under consideration. Speaker, the tall order of business is as set out in the draft statement before us, for both Monday and Tuesday. Speaker, I need to go through the agenda laboriously as it may sound, and I wish to entreat the Hansa Department to deem this as having been read and catch us in the Hansard. Speaker, let me intimate that under your distinguished patronage and that of His Excellency the Vice President of His Excellency Dr. Muhammadu Belmia, we're going to have the Festival of Nine Lessons and Carols in service this evening. And it's intended to at exactly 5 o'clock. Members and staff, and also all the invited guests, are required to be seated at 4:30 in order for the commencement to be initiated at the scheduled hour. I think it's also important, given the circumstances of times, to inform members that given what we've gone through as members of this House, with respect to the rather very intense electioneering campaigns and the conduct of elections, it's become imperative for us all to resubmit ourselves to COVID-19 tests. Arrangements are being made in that direction, and we entreat every member to support himself so as to enable us to enter the clean bill of health. Mr. Speaker, I thank honorable members.
Thank you very much. Honorable Majority Leader. Honorable Kujito Blackwell.
Most grateful, Right Honourable Speaker. Right Honourable Speaker, I thank the majority for the presentation of the business statement. I would want to find out from the Honourable Majority Leader if he can be more specific on the COVID-19 testing arrangements that are being put in place. When you anticipate that you will be ready for members to present themselves for the test. That's very, very important. But you fell short of giving us specific dates of when you think that arrangements will be concluded. And finally, Mr. Speaker, there are major security matters following from the elections. People have been killed. The IGP appeared before the elections and took responsibility that he is in charge of the election security force. Can the task force appear before us to answer questions on matters to do with security, lives that have been lost, and all the security challenges we have faced with the election? It's a very important matter. Either before Tuesday or when we reconvene on the 4th, I think we should create some window for the IGP and members of the task force to appear before this House. I thank you, Mr. Speaker.
Any comments, any concluding remarks?
Speaker, for matters relating to COVID-19 testing, the details are being worked out, and in the fullness of time, the details will be given to members. Certainly not beyond the 22nd of December. Mr. Speaker, the other matter raised by my colleague, that is to invite the security task force that was set up preparatory to the conduct of the elections. It's a request from a member, and we'll put our heads together. Leadership will put our heads together to see what to do under the sixth. Mr. Speaker, I think it's important to inform members that going forward, as between now and the swearing in. It is important for all of us, given the rumors and whispers that keep inundating our space. I don't believe in. However, it's important for the security of members that we make the necessary arrangements via the security outfit in the house, so that we protect ourselves. It's important that you never know what somebody may be. These days, people are becoming very devilish. My own somebody jubilating, and his own very going to stab him because he was wearing a T-shirt of Chairman Sabuzu. I think it's unconscionable. You never would imagine that his own mother's brother will go and stab him, and he stabbed him in the neck. It's unconscionable. We're degenerating to as a country. So, Speaker, if it happens to a member, I don't know what this nation will be thrown into. So it's important for us to measures to protect ourselves. And we are in touch with the security outfit here. If anybody has any peculiar problem, let her through leadership, or perhaps even touching base with our own security to secure protective measures for himself or herself. We need to do that. Not what should happen to anybody between now and in particular the January 7th, when the swearing in of members will happen. So, thank you.
Thank you very much. At this point, the business statement as read is duly adopted. At the commencement of public business, item listed 5, presentation of papers. 5, Minister for Finance.
Mr. Speaker, Deputy Minister for Finance is there.
Honourable Minority, I hope you have no objection for the
Deputy Minister for Finance is there, so you do so on behalf of the substantive minister.
Mr. Speaker, there is no objection. Thank you.
Thank you. Honourable Minister.
Request for import duty, import get fund levy, import NHIL, import VAT, exim levy, special import levy, and domestic VAT amounting to the Ghana cedi equivalent of 13,709,923 euros and 6 cents, made up of 12,554,234 euros in respect of imports and 1,555,689.06 euros in respect of local purchases on materials, equipment, and services to be procured for the construction of a new University of Environment and Sustainable Development at Somenya in the Eastern Region, Phase 2, Constructa Costruzioni Italia SRL.
The paper is due late and is referred to the Finance Committee for consideration and report. Aye.
Request for waiver of import duty, import get fund levy, import NHIL, import VAT, exim levy, import levy, and domestic VAT amounting to the Ghana cedi equivalent of 1,309,008 euros, made up of 1,118,586.85 euros in respect of imports and 240,502.15 euros of local purchases on materials and equipment to be procured for the Upper East Region Water Supply Project by Dennis Engineers and Contractors BV of Netherlands.
The report is due. The request is duly laid and is referred to the Finance for consideration and report. Aye.
Request for waiver of import duty, import get fund levy, import NHIL, import VAT, exim levy, import levy, and domestic VAT amounting to the Ghana cedi equivalent of 13,689,021 euros and 32 cents, made up of 12,336,481 euros in receipt imports and 1,322,840.32 euros in respect of local purchases on machinery, materials, equipment, and services for the construction of a new Takoradi market by Messrs. Construzioni Italia SRL.
Late is referred to the Finance Committee for consideration. B. Chairman of the Finance Committee. I.
Report of the Finance Committee on the Buyer's Credit Agreement between the Republic of Ghana, represented by the Ministry of Finance and the Export-Import Bank for an amount of 158,017,764 United States dollars, and the design and build contract for the Tamale Waliwale Road Phase 1, sub-level to Waliwale, 30 to 113 kilometers.
The report is duly laid and for receiving members. Aye.
Report of the Finance Committee on the request for waiver of import duty, import VAT, import get fund, import oil, exim levy, and special import levy amounting to the Ghana cedi equivalent of 11,402,280 Great Britain pounds on materials and equipment of the design and delivery of prefabricated bridges deployment throughout Ghana by Messrs. Navy Bridge, registered as Astro Global Limited of the United Kingdom.
The report is duly laid for distribution to honorable members. Aye.
Report of the Finance Committee on the request for waiver of import duty, import get fund levy, import NHIL, import VAT, ECOWAS levy, AU levy, inspection fees, withholding tax, exim levy, and special import levy amounting to 120,712 United States dollars, as well as domestic VAT, get fund, and domestic NHIL amounting to 2,114,573 United States dollars, making a grand total of the Ghana cedi equivalent 1,235,200 United States dollars and 33 cents on materials, goods, equipment, and services to be procured in respect of the project for the rehabilitation of the National Trunk Road N8 Phase 2 by Messrs. Shimizu Dai Nippon Venture of Japan, under the grant agreement between the government of the Republic of Ghana and International Cooperation Agency JICA in respect of the rehabilitation of the National Trunk Road N8 Phase 2.
The request due and is for referred to the Finance Committee for consideration and report. C. Chairman of the Committee Rules.
Report of the Committee on Roads and Transport on the contract agreement between the government of the Republic of Ghana, represented by the Ministry of Roads and the JMC India Limited for an amount of $158,617,760 for the design and build contract for the Tamale Waliwale Road and Savlugu to Waliwale, 30 kilometers to 113 kilometers.
Report date and for distribution to honorable members. D. Chairman on Committee for Health. Chairman on the Committee for Health. D. Item 5D. Chairman of the Committee on Health.
Mr. Speaker, the report is not.
Thank you. Chairman E. Chairman Committee Food Agric.
Report of the Committee on Food, Agriculture and Cocoa Affairs on the Charter of Cote d'Ivoire, Ghana Cocoa Initiative, CGCI.
It is duly presented and for distribution to honorable members. I.
Report of the Committee on Food, Agriculture and Cocoa Affairs on the head agreement between the Government of the Republic of Ghana and the Cote d'Ivoire Ghana Cocoa Initiative for the establishment in Accra of the headquarters of the Cote d'Ivoire Ghana Cocoa Initiative, CIGCI.
The report is duly presented and for distribution. F. Chairman, Defense. Chairman, Committee of Defense and Interior.
Speaker, you may have to stand item 5F time being.
Item 6. Can we take that today? Item 7. Committee on Environment.
Rise to move motion number 7 on today's order paper P3 that this adopts the report of the Committee on Environment, Science and Technology on the budget performance report in respect of the Ministry of Environment, Science, Technology and Innovation for the period January to December 2019. And doing so, Mr. Speaker, I present the report. I will urge the House of Debate to capture the whole report as being read. Whilst I look at a few observations and conclusion. Mr. Speaker, the committee during the review meeting made the following observations. The first one being that the committee realized that the ministry overspent its approved budget under goods and services. An amount of 83,724,900 CDs was approved by Parliament for their operations under goods and services. But the ministry has spent an amount of 119,411,167 Ghana cedis, 13 pesos. The committee was informed that the increase was as a result of extra funds provided by the Ministry for the payment of subscription fees for the Ghana Atomic Energy Commission. Mr. Speaker, it was observed that the EPA collaborates with the Water Resources Management Committee to monitor polluted waters. The committee was informed that the pollution of our waters through activities like Galamsey has led to some communities of their sources of water. The committee recommends that EPA should increase the level of collaboration to ensure that it is better protected. Mr. Speaker, the committee, after critical consideration of the 2019 budget report of the Ministry of Environment, Science, Technology and Innovation, recommends that its report be adopted. Must be submitted, Mr. Speaker.
Who seconds?
All right, Honorable Speaker. I rise to second the motion moved by the chairman of the committee and to make few comments of my own. Mr. Speaker, this is a requirement of the ministry to come back to Parliament and present the budget performance to the House. As captured by the chairman, in concern was for Environmental Protection Agency to work with other or collaborate better with other agencies to make their efforts protect the environment better. And I think that is great, and we encourage the ministry in the coming years to do that effectively to ensure that we protect our environment and our future. Thank you very much, Mr. Speaker, for the opportunity.
Thank you very much, Honorable. I have a question. All those in favor of the motion listed 7 say aye. Those against, the ayes have it. 8. Committee on Employment. Chairman for Employment. Nine. Committee on Foreign Affairs. Honorable Anodo, Chairman of the Committee on Foreign Affairs. Item listed 9.
Speaker, the report is not yet ready. Thank you, Speaker.
Thank you. Item 11, motion. Minister for Foreign Affairs. Item listed 12. Motion. Honorable Mubarak, where are you? Honorable Majority Leader, Honorable Minority Leader, Honorable Mubarak. Who motion, please?
Mr. Speaker, I beg to move that, notwithstanding the provisions of Order 81, which require that no motion shall be debated until 48 hours have elapsed between the date on which the notice is given and the date on which the motion is moved. The motion for the second reading of the Road Traffic Amendment Bill 2020 may be moved today. Accordingly, I so move, Speaker.
Thank you very much. Yes, Honorable Minority Leader.
Mr. Speaker, I beg to second the motion ably moved by the Majority Leader. Thank you.
I'm going move the second. All those in favor say aye. Those against say no. The ayes have it. Substantive motion 13. Yes, Honorable Majority Leader.
Mr. Speaker, I beg to move that the Road Traffic Bill, Amendment Bill 2020, be now read a second time. The Speaker, so in my capacity as moving this motion for it to be read in my capacity as the Majority Leader and Leader of Government Business. I have moved it. I want to present the committee's report in my capacity as a sponsor.
Honorable IP.
As a sponsor of this bill, I would want to speak to the principle underpinning the amendment that we are proposing. And the object of this amendment bill to amend the Road Traffic Act 2004 at 683 to prescribe acts that constitute dangerous driving and dangerous cycling that result in the death of human fetus and for related matters. The Speaker, you would remember that one of the most recent bills that we passed relate to registration of births and deaths, and we gave space for the registration of deaths of fetus, and that becomes imperative to situate it in the context of this bill. The Speaker, the Road Traffic Act 2004 at 683, which was subsequently amended by the Road Traffic Act 2008 at 671, generally provides for the protection of children. Section 14, for example, prohibits a person from driving a motor vehicle on a road when the child of 5 years or under 5 years is at the front seat of the motor vehicle. Section 15 empowers the minister to provide types of safety equipment that are recommended as conducive to the safety of children in the event of and to be fitted in the presented classes of motor vehicles. Speaker, however, at 683 is silent on legal remedies for an unborn where a road traffic crash occurs. Information from the police and healthcare facilities indicate that a considerable number of women have lost their pregnancies as a result of the crashes. Also, Act 683 does not impose a duty on a driver of a motor vehicle to report the death of an unborn child on the occurrence of a road crash, and it is impossible to charge an accused person for the death of an unborn child. Mr. Speaker, the absence of a duty to report the death of an unborn child in a road traffic crash inadvertently results in the absence of data on the subject which may be relevant for national development planning purposes. In particular, as I have already recounted, the act that we passed, the registration of births and deaths, which includes the registration of the death of fetus. So, Mr. Speaker, considering the international practice, state laws from Kansas, Kentucky, and South Carolina define an unborn child as a living of the species of Homo sapiens in utero from conception onwards to fertilization, as there are penalties for persons who cause injury or death to the unborn children in those jurisdictions. The Nebraska revised statute also provides a penalty for motor vehicle homicide of an unborn child in wrongful death cases. It specifies that motor vehicle homicide of an unborn child should be treated as a separate and distinct case. Queensland, Australia, which is a Commonwealth jurisdiction, introduced a specific fetal homicide laws in 1997, under which a driver of a motor vehicle may be charged with a separate offense of killing an unborn child, the sanction for which is a maximum penalty of life imprisonment. The Speaker, in order to protect posterity, particularly in the case of road transport, the bill seeks to amend Road Traffic Act 2004 to ensure that the law recognizes the loss of an unborn child as a separate and distinct law, not only an injury suffered by a pregnant woman. Mr. Speaker, it is for this that this amendment to the Road Traffic Amendment Bill is being proposed, and I hope and trust that members would join ranks with the sponsors to pass this bill, this amendment bill, as soon as in order to commensurately amend the act that Parliament has passed. The Speaker, I so submit.
Honourable Minority Leader.
Speaker, I would indulge you to second the motion and to speak favorably for it, but to further pray that you probably may allow one or two of our colleagues beyond this to make some comments on this particular matter, Mr. Speaker. So I second the motion ably moved by the majority leader and leader of business for an amendment to the Road Traffic Act 2004, Act 683, to proscribe acts that constitute dangerous driving that results in the injury or death of an unborn baby. The Speaker, probably Act 683 didn't contemplate this because that unborn baby is still not a natural person. But the consequence is the closeness of the accident may impact on the person. Maybe are we seeking to provide? Mr. Speaker, it reminds me that as a country and as a parliament, I should note that this will be one of your enduring legacies as Speaker of the 7th Parliament, that at long last, this Parliament has recognized and given meaning and opportunity to a private member's bill, regardless of contentions and arguments as to whether the chairman, so the chairman will submit the report. So, Mr. Speaker, in principle, I think this will go into the record as one of your enduring legacies as Speaker, and to the entire House, that this is the first of its kind and a novel which will contribute to enriching our parliamentary prudence and contributing to encourage members to find gaps and deficits or deficiencies in existing legislations and not to hesitate and be courageous in making same recommendations. So, Mr. Speaker, I strongly support this private member's bill and trust that, as I said, the chairman will submit his report. You probably may tolerate one or two of our colleagues with and the sponsors with the understanding of the subject matter to speak to it. So this is history making for the Parliament of Ghana and the 7th. I should commend you, Mr. Speaker, for courageously accepting and leading the process for this to happen. I thank you for the opportunity.
Thank you very much, Chairman.
Thank you, Honorable Speaker. Honorable Speaker, I rise to associate myself motion on the floor and also seek your indulgence to report your committee's report. Speaker, I'll ask the Hansa Department to pick the school report I've been read, files and read highlights of the report. So, Speaker, the Road Traffic Act 2004, Act 68, secondly amended by the Road Traffic Amendment 2008, Act 761, provides for the protection of all road users. Section 14 of Act 683, for instance, prohibits a person from driving a motor vehicle on the road when a child of 5 or under 5 years is at the front seat of the motor vehicle. Section 15 of that says empowers the minister to prescribe safety equipment that are recommended as conducive to this in the presented classes of motor vehicle for the safety of children in the event of an accident. The Road Traffic Act 2004 at 680 is silent on legal remedies for an unborn child where a road traffic crash occurred. Information from the police and the healthcare facilities indicates that considerable number of women lost their pregnancy because of road traffic crashes. The Speaker at 683 does not impose a duty on the driver vehicle to report the death of an unborn child in occurrence occurrence of road traffic crashes, and it is also impossible to charge an accused person for the death of an unborn child. The absence of a duty to report the death of an unborn child in road traffic crashes ultimately results in the absence of data on the subject, which may be relevant for national planning. Subsequently, the need for this bill. The Speaker, the bill seeks to amend the Road Traffic Act 204 at 683 to prescribe acts that constitute dangerous driving and dangerous cycling that result in injury or death of a child and for related matters. The Speaker highlights of the bill. Clause 1 of the bill 6 men Act 1, Section 1 of Act 683 to prohibit the driver of a motor vehicle from driving dangerously on a road has resulted in injury or death of a person, including unborn child. Clause 2. Similarly, 6 men Act 30, Section 30 of Act 683 by prohibiting a person who rides, cycle dangerously on the road that results in injury or death of an unborn child. Clause 3 of the bill seeks to amend Section 124 of Act 683 to impose a duty on the driver of a motor vehicle to, as soon as reasonable practicable, report a police station on occurrence of an accident that results in injury or death of an unborn child. The Speaker, the committee bill noted that the bill is of an urgent and that has to be passed under certificate of urgency. Recommendation and conclusion, Mr. Speaker. The Road Traffic Act 204 amended to prescribe acts that constitute driving and dangerous cycling that result in injury or death of unborn children, and also in providing data on the subjects which may be relevant to national development planning. The committee recommends to the House to approve its report and pass the Road Traffic Amendment Bill 2020, which is the major members' bill in the Fourth Republic, preside to the attached amendment. Respectfully submitted. Thank you, Mr. Speaker.
Thank you very much. Yes, Honorable.
Right, Honorable Speaker, thank you for the opportunity to contribute to this very important bill, and also commend you for leading Parliament to break the glass ceiling on this issue. Mr. Speaker, I am sure if we go through our laws, there will be various reasons why we should embark on this journey, and I'm sure this Parliament will be remembered. Mr. Speaker, I would just want to tell the Chairman that one of the cardinal reasons of this report is to give the plenary the opportunity to take this bill under a certificate of urgency, which is missing in what the two leaders have said and the Chairman have said. One of the decisions we need to take is to agree that we are going to report on this bill under the certificate of urgency. But I know it's in the report, and everybody said the Hansa should capture it. So that's one of the decisions we need to take. Mr. Speaker, it is very true the current law doesn't recognize the injury or death of an unborn child as is captured in this report. Mr. Speaker, all the things that are said, one of the things the existing law puts the burden on the driver or the rider to report the accident. Mr. Speaker, at the committee level, I made them aware not all the times that the culprit is even in the position to report to the police. Because, in fact, you could be driving dangerously and be involved in an accident. So you are the same person who actually caused the accident anyway. So it's not always the case that culprit is somebody else and there's a third party who is the victim. So, and it could also happen that when the accident happened, the person who caused it is incapacitated. So to put a burden of reporting on the person actually is, that is why the police colleagues at MTTD comes up with that, and at the committee level, we were helped appropriately by the National Road Safety Authority, that actually at that stage couldn't necessarily be on the person who is being accused. Secondly, Mr. Speaker, it could happen that somebody gets involved, an accident happens, and somebody was pregnant at the time the accident happened. The defect on the child was only realized 10 years after they had been born. The case on that accident could even be the window, but there could be medical reason to prove that that defect was as a result of that accident 10 years ago. In this case, if proven medically, there still be remedy for the victim in this case, who is now a child and living. So it goes beyond death of a fetus or an immediate remedy. It could be a remedy that can be extracted long after the actual incident, proven medically, it can be proven. Mr. Speaker, the second thing I want to say is this. This also means that we should all observe the measures that are required. Mr. Speaker, if you're pregnant and you sit in a vehicle and you don't strap appropriately, because I know at a certain level of pregnancy, the ambition as to how you secure yourself in a vehicle. If you observe those and then you are involved in an accident, there's no automatic law that will give you a remedy to that. So it means that there's a part that we must play as people who want to pregnant women, and then that will be played by cyclists and riders. Mr. Speaker, I think this is a very if we are able to pass this to close loopholes in the current law and to give justice to victims. Mr. Speaker, at the committee level, there was argument as to what age this happened, because some people call it fetal, some people call it unborn child. We decided that would be dangerous, because medically proven that somebody is pregnant, it's not necessary to prove whether it's 1 month or 2 months or 9 months. An unborn child is an unborn child. So the medical advice is that we should not get involved listing which age of pregnancy this should happen. As long as we have medical doctors, they'll prove to you whether the person was pregnant. Because the fact that a pregnant woman was on a vehicle and an accident happened doesn't necessarily mean that if he loses the baby, it doesn't automatically mean that it is as a result of the accident. It could be anything else. I'm sure the medical profession will be able to gather. Mr. Speaker, I speak favorably to this and encourage colleagues to do the same for us to make history that will save a lot of people in this country where currently there's no remedy for these people. I recommend colleagues to support this for us to make history, and commend you, Mr. Speaker, highly for taking this step. And I'm sure in the future we could do more of these things. Thank you very much for the opportunity.
Thank you very much, Honorable Mover. Then Honorable Dombre, and then the Honorable Minority Chief Whip. Yes.
Mr. Speaker, I thank you very much indeed for the opportunity to pass this private member legislation. And as has been indicated, this will go into history as one of the very important legislations that have been passed in this House. This is not only about us, but it is about the future. It is about children who are yet to be born. And if we can provide remedies in our laws for pregnant women who may be involved in accidents that could affect the babies, it is very exciting. This is what Parliament should be and is about. Mr. Speaker, I thank you for creating the space. This is also to thank colleagues who have contributed in making this possible. Mr. Speaker, there was a case in South Africa where a pregnant woman was involved in an accident. Now, the child got brain damaged. It was only realized after delivery that the injury to the child was as a result of an accident that occurred several months in the past. So indeed, this would go a long to helping your grandchildren, to helping our sisters, our wives, who on a daily basis is faced with the dangers of cyclist drivers who are driving or riding without regard to passengers they are carrying or pedestrians on the road. So what this seeks to do is to impose a burden, Mr. Speaker, drivers to be careful when they are driving. It is to impose a burden on motor riders to be careful when they are riding their motorbikes on the road. I think that it is historic, and we are grateful for the opportunity. With these few words, I would encourage the House to approve of this under a certificate of early, and I believe posterity will judge all of us kindly. I thank you very much indeed, Mr. Speaker.
Honorable Anodumbre.
Speaker, I rise to speak definitely in support of the motion and not to repeat what my colleagues have spoken earlier. I think that it's clear what the amendment is seeking to cure. I want to commend the sponsors of the bill, particularly Speaker, your good self. We are making history, and it will go a long way to enhance our democracy and our legislation as a country. Speaker, I think that one of the things we are missing out is, in as much as we pride ourselves on the historic nature of, we don't have to gloss over other essentials like the Road Safety Commission and the Ghana Police Service, who clearly would have a role to play, because if liability will be enhanced in proper context, mainly because of the amendment. What it means is that police service and the Road Safety Commission's work would have to change. The approach of work would have to change. So going forward, we also strengthen the be able to dispense of their work effectively and creditably. Speaker, in conclusion, I think that the legality of Parliament would also have to be strengthened, because it is definitely a new where private members' bill entertained and supported. Hence, the capacity of our legal department as an institution or as an arm of government would have to be enhanced, and their capacity built to be able to cope with speed. So that is what I want to bring to bear and in wake. But also, I think that the House must commend the Speaker, must commend the sponsors of this bill. It will go down as historic landmark legislation, and it's something that we have to be proud of. And I'm confident that going forward, the 8th Parliament, there is going to be a plethora of private members' bill, not just for the sake of it, but also seeking to cure loopholes that we have in the number of legislation that we have. So I fully associate myself with the motion, and I urge members to support it accordingly. Thank you, Speaker.
Honorable Proceedings, the leadership.
Thank you, Mr. Speaker. Mr. Speaker, it is said that change doesn't come easily. It comes from people with a conviction, dedication, focus in whatever they do. Mr. Speaker, there is no doubt that under the leadership of the Speaker, we have expanded the frontiers of democracy and challenged the scope. Now it will be possible for members to initiate and bring before this House private members complement the efforts of government. Mr. Speaker, members of Parliament, now under your leadership, given the privilege to have bills in their name, that can only be the benefit to our democracy and also the recognition by the Speaker
that this is the way to go. So it will not be out of place, Mr. Speaker, to commend you and your leadership for this bold step. Once upon a time, it was said that every legislation, every piece of legislation will be a charge on the consolidated fund. And that being so, private members' bill could not be entertained in this House. The Speaker has demonstrated that it can, and it is being considered. Mr. Speaker, the majority leader has said that a few weeks ago, he passed a new legislation, the Birth and Death Registry Act, in which we accounted for in the provisions of the Act the death of a fetus. The Speaker, is tried law that a fetus is not a natural person, don't have rights. But what are we doing, the Speaker? Today we are reaching out, one, to our sisters, aunties, and mothers and daughters, that in the consideration of legislation in this House, and particularly for their welfare, Parliament is willing to consider and legislate on the dangers they will be exposed to when they are using the road, especially in the condition of pregnancy. We are imposing additional responsibility of care on other roads when they are to be mindful of the women on the road, in their vehicles, in their receptacles, so that they do not compromise the health of the women. The Speaker, we are saying by what we are doing today that it is possible for members of this House to close the gaps. That's what we are saying, and we can only commend you and commend ourselves for this bold initiative. I am leaving Parliament, and that's why I was itching to talk. The Speaker, I want my name to be as one of those who spoke in favor of this bold initiative, and that the 8th Parliament will take advantage. It started today to complement the efforts of government in closing the gaps in legislation for the general benefit of the people of this country. Thank you, Mr. Speaker.
Honorable Fuseni. Yes, Honorable Minority Chief. Well, let's see. Is any voice on my right? Otherwise, we'll hear the Honorable Adia, the only leader, the only person on her feet. No, Adia can speak for herself, and that will be the last contribution, unless, yes, before leadership. Honorable, I will come to leadership. Yes.
For the opportunity.
Now that people are talking about historic record, please go. Honorable.
Oh, thank you, Mr. Speaker, for the opportunity. Mr. Speaker, as a member of the committee, yesterday I was really impressed and very happy when I got into the committee, only to read this private members bill, which was brought under a certificate of urgency. Mr. Speaker, as a woman, there's nothing more delightful than having this bill being passed. Mr. Speaker, in the deliberations at committee level, we actually went into details because there were questions of when we would call a child, unborn child, a fetus or a zygote, and what have you. So we came to the conclusion, no need giving a specific name other than an unborn child. Because at any level, at least, life had started in the woman's womb. And, Mr. Speaker, we got to a stage where we were worried about if it's at the early stages of about 6 weeks, 3 weeks, 1 week, how will the police, or sometimes with some women, you may not detect whether the child is actually alive or not alive, whether the child or not hurt. How would that problem be solved? It was made clear that this is now going to be a responsibility of the medical people, of the police, that is the MTTU, and the officers in charge of the case, and that it is their responsibility not to close the docket, because we realize that there is a situation where at the end of the day to the police and they, oh, that docket was closed, and the one who is affected might not know what to do, and it behoves on the pregnant woman to who would say, yes, I am pregnant or I am not pregnant. It's part of her responsibility. But the health people should be those who will determine and be able to tell whether it will be affected, the child would be, the unborn child would be affected or not, so that if even the woman herself hurt or even she is dead, we will be able to tell what has happened at the end of the day. Mr. Speaker, all we are grateful for is that we have seen women in accidents who have died and their children have died later because of the accident. Not because they wouldn't have, because we know at about 7 months, some women are able to give birth to premature children. And then maybe some women are even within that month, they have an accident, they die, and then the child is later on, and nothing is done about it. So we are really grateful for this, and we only hope and pray that all others who are supposed to help us for this bill to work, not for it to be a 9-day wonder, something on paper would help us so that the bill will work, and our appreciation at the end of to you, Mr. Speaker, who has given us the opportunity to come about with this private members bill, and we are really grateful, and I think that we thank our colleagues who have supported us to bring this bill to reality. Mr. Speaker, I thank you for the opportunity.
Thank you very much, Madam. Honorable Muntaka.
Thank you, Mr. Speaker, for this opportunity to be part of the history making, and to sincerely thank you, Mr. Speaker, for the courage to at least get this shell broken. I remember very well in your inaugural speech, you reiterated how you wanted to see this House overcome this challenge. I want to admit, you yourself have seen the challenge and the difficulty when attempt was made to introduce a number of them. And I must even say, had it not been your resilience, looking at the tail end of the parliament, you would have given up. But you were still insisting we should do whatever it takes to break this barrier. I hope that this barrier is truly broken when we are done with this two, so that tomorrow, regardless of what happened beyond this parliament, this House will continue to have the courage to move on, able to complement government effort in shaping our laws. Mr. Speaker, this act, this amendment is a very important one, knowing the harm that road accidents cause, especially to the unborn baby, that our country, until if we are lucky to pass this through and get the president to assent to it, do not recognize as part of persons that have been hurt or killed and this to be accounted for. So, Speaker, my is that if you look at the act and the proposal, we tend to limit the punishment to only confinement. And when we get to consideration stage, we may reconsider that. We are assuming, by the way it is called, that accidents that are caused deliberate, the way it is called. But we all know that's why it's called an accident. if it's an accident, there could be a circumstance that the judge should be given the opportunity not to confine, but to fine the individual. To leave this punishment to only confinement, Mr. Speaker, I think it's worrying. We say in the what do you call the bill itself, 1A, you say a person rides a cycle dangerously on a road that results in the death of an unborn child, commits an offence and is liable on summary conviction to a term of prison of not less than 3 years and not more than 7 years. We tie in the hands of the judge. And Mr. Speaker, as all of us in our driving lives will admit, there are some instances that you see genuinely that yes, an accident occurred, but it wasn't a deliberate or careless driving, even though one could describe how to run into the sideway or knock the lane as part of the definition that we have there for the dangerous driving. So I want to, when we get there, to look at possibility of also creating fines so that we leave the leverage to the judge to be able to navigate. The Speaker say that looking at the long title, yes, it restricts us to only the issue of the dangerous driving in the death of human fetus and related matters. The Speaker, I presented an amendment to this same act and was being worked on concurrently. Unfortunately, I really wish all of them were put together, because I thought that that one was even much easier to do than this one because of the technicalities that were involved. And Mr. Speaker, it has to do with the age of driving. Mr. Speaker, all around the world, they move away from 18 years. They provide room for people to start learning, and you start at 16 with restriction. You cannot drive with passengers. You cannot drive in the night. And when you are driving with when you are 16, you be a qualified driver sitting in. Mr. Speaker, today we keep talking about the 18, yet our children at 16, 17 are daring to drive, and we are not giving them the opportunity like in Europe and what is happening. I really wish that our draft legal person, I mean, must commend her. She's done fantastically well. She's been very hardworking with so many of the things that we wanted to do. I really wish all of them were put together so that at least since we are looking at the road traffic, we'll have dealt with them together. I don't know, maybe when we get to proceed, whether a caveat could be provided for that to be added, because it talks about related matters. I don't know how reducing the maybe the age could be related to unborn child, but maybe when we get to a consistency, we'll say what we can do. Mr. Speaker, this singular thing that we are doing today, repeating myself, must be acknowledged that you had really put almost all your behind it. And I can definitely say, had it not been that, we wouldn't have been where we are. I'm happy that the leaders are part of it, and knowing very well that the leaders are continuing as members of parliament, and many of us who are in the opportunity to contribute, will take this theme and not let it die off, so that into the next parliament, we will see many more private bills that will come to augment lawmaking in our country. I want to thank you once again for the opportunity to contribute to this motion. Thank you very much, Mr. Speaker.
Honourable members, in view of the business ahead of us and the time now, I direct that continues beyond the prescribed. Minister for Roads. Honourable Minister for Roads.
Thank you, Mr. Speaker. Mr. Speaker, I would thank you most sincerely for allowing me to add my voice and to associate myself to this all important bill being considered, which will eventually if it goes through, will bring the amendment, the current road traffic bill. And what we are trying to seek to do to make sure that we bring sanity on our road. Mr. Speaker, in most cases, we do not pay heed to the unborn child, but it is important to take note that right from the fetus stage until the child is born, the child the duty of care, not only from the mother who carries the conception, but even though not yet born, all of us owe such unborn children duty of care, including drivers. Today will go down history, Mr. Speaker, as the first time private members' bill is being considered since the inception of the Fourth Republic. And your good self, as all those who are proposing this, will also go down history, because record and will reveal that we made an excellent move that will be with this parliament, and the name of this seventh parliament will also go down history. The difficulty of private members' bill, Mr. Speaker, had always been for the fact that it will impose a charge on the consolidated fund, as is contained in Article 108A2. And Mr. Speaker, with your permission, I would like to read that this Parliament shall not, and the bill is introduced or the motion is introduced by or on behalf of the President, A. Roman number, because of the imposition of a charge on the consolidated fund or other public fund of Ghana, or the alteration of any such charge otherwise than by reduction. This had always been the impediment in the way of introducing a members' bill. But I am so happy about this particular bill because it will come into effect if it's eventually adopted, but it will not impose any on the consolidated fund, because this is a subject that will be dealt with by insurance company. And I believe that members of this August House think and direct their mind on such imposition of taxes that will not the consolidated fund. We may be able to out a number of such private members' bill that will promote the work of this House. And it's a very good move. It's a direction that encourages the work of this House and bring the unity of members of Parliament. And with this, Mr. Speaker, I want to urge that we carry it through. I thank you, Speaker.
Thank you very much, Honourable Minister for Roads. At the conclusion of the debate, all those in favour of the motions listed 13, The motion number 13, that the motion that the bill be read a second time, particularly with regard to it being taken under a certificate of urgency, should please say aye. Those against say no. The ayes have it. The motion
An
is
act to amend the Road Traffic Act 2004 Act 3 to prescribe acts that constitute dangerous driving and dangerous cycling that results in the death of a human fetus and for related matters.
The Road Traffic Amendment Bill 2020 is duly read a second time. Item 14. Item listed 14.
Mr. Speaker.
Yes, sir.
I beg that notwithstanding the provisions of Standing Order 1281, which requires bill has been read a second time, we shall pass through consideration stage, which shall not be taken until at least 48 hours have elapsed. The consideration stage of the Amendment Bill 2020 may be taken today. I so move.
Thank you very much. Yes, Honorable Mubarak.
I suspend the motion.
Thank you very much. All those in favor say aye. Those against say no. The ayes have it. Vote. Constitution stage. Road Traffic Amendment Bill 2020 at the consideration stage. Aye. Plus 1.
Section 1 of Act 683.
Chairman of the committee.
Thank you, Raul. Item I. Plus 1. Amendment proposed. Delete and insert the following as advertised. I so move, Mr. Speaker.
Mr. Speaker, I agree to the proposed amendment by the chairman of the committee. I believe we have to further the B, which provides that in C, by the insertion after occurs of including the death of an unborn baby. Mr. Speaker, appropriately, the insertion should come after death, not occurs, because the original, which is what we are proposing to amend, reads, where death occurs. And we're inserting, the proposal is to insert, including the death of an unborn child, so that it will read, death occurs, including the death of an unborn baby, to a term of imprisonment for a term not less than 3 years. Mr. Speaker, it should probably read, where death, including the death of an unborn baby, occurs, including occurs. The occurs
death, including the death of an unborn baby.
The death of an unborn baby occurs. Mr. Speaker, that is how it should.
So occurs comes as a baby.
As soon as I met.
Yes, Honorable.
Mr. Speaker, what we said yesterday was unborn child, not unborn baby. So, yes, so
shall we keep child?
Yes, so for consistency, unborn child will be better than unborn baby.
Bill,
some colleagues are asking what is an unborn baby, unborn child. Mr. Speaker, once a qualified medical person can prove that a conception has taken place, it doesn't matter whether it is 1 week, 2 months, until the end of term when the baby comes out, that is all unborn. We deliberately refuse to describe what an unborn child, because that is our job to do. Because somebody's pregnancy can be confirmed in a week, or it could be 2 weeks. We in Parliament shouldn't begin to do that. The medical fraternity will be able to do that appropriately, even prove it in court. Mr. Speaker, thank you very much.
Yes, Honorable.
Mr. Speaker, thank you for giving me the opportunity. Who is unborn child? Are we talking about the fetus or unborn child? Look at the Parents Act, the amendment bill. There is no definition for unborn child. What do you mean there is no need to do that? So how do I know
Honorable,
this is unborn child?
Make up and let us not fight over anything.
Mr. Speaker.
Yes.
Mr. Speaker, when a pregnancy is a certain stage, it is no longer a fetus. To avoid, because a fetus is only up to a certain point. When somebody is in the stomach for 8 months, it's no longer a fetus. That is why it's unborn child. Pardon? You see, a fetus, medical people will tell you, when you are 8 months, you are no longer a fetus.
Mr. Speaker, respectfully, conception is not in the stomach.
Mr. Speaker, my majority leader is right. But the womb. No. When we say, Mr. Speaker, Mr. Speaker, no. Mr. Speaker, if I were to ask the majority to show me where a womb is, you'll be pointing somewhere here. What is that? so the baby is not in a womb. Mr. Speaker, the medical fraternity knows where a womb is. Conception doesn't take place in the intestines; it takes place in the womb, and that is what we are talking about. Mr. Speaker.
Mr. Speaker, an unborn has been defined as a child that has not yet been born, that is still in the womb. It's an unborn child. But Mr. Speaker, which child are we seeking? Which unborn child are we seeking to protect? Because pregnancy has cycles. We have the first trimester, the second trimester, and then. Now, in the first trimester, the child is a and a miscarriage can occur naturally. Miscarriage could occur to coincide with an accident. So, So, now in the US jurisprudence, unborn child is a child still in the womb 8 years, 8 months, 8 weeks. No, 8. Mr. Speaker, I was just looking at it. It's 8. Just saw it. Mr. Speaker, so what the U.S. jurisprudence is that they fix the responsibility at a certain point and recognize when anything happens to the pregnancy at that point is an offense. That is why you can't have an abortion, a legal abortion, after a certain number of weeks of pregnancy in the United States, in some states in the United States of America. And so I was thinking that we should also, and there are doctors here, I was thinking that we should also be guided. Because, Mr. Speaker, if I am a trotro driver at, and passengers are entering my vehicle, and do I have to ask all the women whether they are pregnant? Because I can't see that they are pregnant. I can't see their protruders, but I'm putting a responsibility on the driver to drive carefully. Will it be fair to do that? So I'm just thinking that, shouldn't we define an unborn child into the number of weeks of the pregnancy, so that the protruding stomach would be a manifestation and a warning to anybody that somebody is pregnant on the road. Thank you, Mr. Speaker.
Mr. Speaker, in other jurisdictions where this participation exists, they couch it to coincide with the period of pregnancy. So, for instance, in the past, once one pregnant for more than 26 weeks, the baby is assumed to have a life of its own and can even exist outside of the womb. Mediators and other things that can hold the baby. There's been improvement in Europe and America. Even for 18 weeks, they have systems where the baby could still survive outside of the womb. So, in agreeing to what the Honorable Inus Afuseni MP Central has said, we should couch it in a way that takes into consideration the period of pregnancy. And in the draft legislation that initially came, the suggestion was to have pregnancy that is up to 22 weeks. No, that's the point. No, fetus that is up to 22 weeks. But suggestions came to the extent that, I'm sorry, 12 weeks. But technology is evolving. If you restrict it to a certain amount of time, you may miss out with the benefit of technology.
Thank you very much. Now, Chairman, let's
thank you, Honorable Speaker.
Chairman,
drop my
Honorable Chairman, if we can
amendment.
Honorable Chairman, please.
Mr. Speaker, I want to.
If we can take some guidance from the Honorable First Speaker, who got up, then as Chairman you can conclude. Yes, Honorable First Speaker.
Now, I was worried about why we were spending so much time on how old a pregnancy must be to define an unborn child. Once it is in the womb and it has not come out, it is unborn, no matter how long it has stayed in. I've seen women who have been, one of my classmates was pregnant for about 1.5 years. So, right, yes, it happened. He was my classmate.
It can happen.
If it should not deliver after the 1 year old and get injured, that what is in her womb is one child. Is that what we are suggesting? So I don't think we should spend time trying to define what is an unborn child. It is known and time, and that thereby cutting out other people carrying in the womb beyond the time we give. So we should not give ourselves any 22 months, 18 months, 22 weeks or 18 weeks, as long as
unborn child.
another is unborn. It remains in the womb of a mother. It is an unborn child. So who are we legislating for? Who are we legislating for? This become a view is that we should not waste time with time period of weeks and so on. Thank you, sir.
Mr. Speaker, the danger of what the Speaker is proposing is conception starts when the sperm comes into contact with the egg. Until the woman attains the menstrual cycle, which she may miss, conception has already taken place. And the woman will not even know that she's pregnant. So we didn't know. So until even the 4th week, you wouldn't know. And yet it would have begun. That is why it is always defined to have a cutoff point. Mr. Speaker, is the reason why in the registration of births and deaths, we restricted ourselves to fetus and use fetus so that at least it will synchronize and be in sync with the registration of births and deaths, the acts that we did. So I would suggest that we use the term fetus and cut out whether unborn child or baby.
Chairman, please give us the formulation and let's move with progress.
So, Mr. Speaker, I therefore drop my amendments.
So we need fetus.
So
the entire amendment
of
fetus, yes, including the death of the fetus. Thank you.
Well, if the amendment is going to discuss.
Mr. Speaker.
Honorable Chair.
Mr. Speaker.
Thank you, Mr. Speaker. Mr. Speaker, the proposal by the leader is in sync with the definition of an unborn baby, not child, unborn baby. Fetus is from the 8th week. That's the time they start declaring it as a fetus. 8th week until birth. And so that term is rather preferable. Or unborn baby. Fetus or unborn baby. Thank you very much, Mr. Speaker.
So are we going by the expression unborn child? Or what?
Mr. Speaker, the majority leader's latest rendition is better. Mr. Speaker, indeed, if you read the Oxford Dictionary of a fetus, it says a human being or an animal as it is developing in the uterus before birth. So it takes away the of segregating at which period, and after the organs have started forming. So if we use this, it's actually in line with other laws we've passed, so that we avoid an unborn child or other things and use fetus. I think that will be safer and consistent with other laws we passed, Mr. Speaker.
That's a further amendment. Yes, Honorable Eriga.
Thank you very much, Mr. Speaker. Mr. Speaker, I think this has been a very heated within the context of U.S. Supreme Court adjudication of abortion matters. And I'm sure Mr. Speaker is aware that the way that the U.S. has responded is to say that, in a sense, you cannot ascribe rights to an unborn baby or child or what, but that a fetus in the trimester, the last 3 months, at that point, the Supreme Court is willing to give recognition that kind of fetus cannot be aborted and it will not constitute
murder or anything of that. And I think that is exactly what we are confronted with today. When you say a fetus, at what stage? At what stage? Is it, the first, the second 3 months, from the 8th week onwards? Yes. Which places it in the 3rd trimester. So if we do that, then we would be making in terms of adopting the precedent in the United States. So, Mr. Speaker, I support the argument that we have to use the word child because it is not really a child. It's not a child that has not been born. It's technically the word is a fetus. Thank you very much, Mr. Speaker.
Honourable member for Adako. Therefore, will you give us just for
Mr. Speaker, in the chairman's rendition in clause 1, he proposed, he used in A, unborn baby. And then the majority leader helped us by saying, let's just...
Please read us the rendition.
Okay, so the rendition will be A, in paragraph, by the insertion after where of there is an injury to a fetus, and B, in paragraph C, by the insertion after occurred of including death of a fetus. Mr. Speaker.
So a pregnancy is contaminous with a fetus until the child is delivered.
Yes, Mr. Speaker. That is fetus. To birth is fetus.
Yes.
Speaker, yes.
Doctor.
For those of us who are not medical doctors, I'm wondering, the woman dies. Is it going to be important for a medical doctor to certify that it's a fetus
or not?
Or not? Because otherwise, how do you know? So it looks like after that, you need a medical doctor to ensure that it's a fetus.
Or not, or an embryo.
That is assumed. Onerous requirement.
That is assumed.
It's not an onerous requirement on this particular one.
Yes, honourable majority there.
Mr. Speaker, the honourable member who just spoke, is devout Catholic.
Is what?
He's a devout Catholic, and he knows the theology and Catholicism about the status of who an unborn
He objects.
Mr. Speaker, he knows.
The honourable member objects.
I don't know why he's bringing my religion into this matter. But no, Mr. Speaker, it's an important question. Let's be sure that that's the spirit that we want to do.
When there's a need for medical certification, it will be done.
Insist on the medical certification.
Yes.
I think that need to be okay.
It must be a necessary part of a trial. Otherwise, you can't get conviction. So let's go on. All those in favor of the formulation say aye. Against say no. The ayes have it. And on clause 1, Mr. Chairman, Honourable Chairman, please follow your brief. Is there anything else, Honourable Chairman, you want to add to 1? If that is all, then I'll put the question on the clause as a whole. And that clause 1, as amended, should stand part of the bill. All those in favor say aye. Those who say no, the ayes have it. Clause 2.
Section 30 of Act 683 amended.
Chairman.
Thank you, Honourable Speaker. Clause 2, amendment proposed, paragraph C, delete.
And the reason is that, please satisfy us. Tell us why and how it will read at the end, so that it will read, then honourable members will see the point more clearly.
Speaker, the Parents Act that we are amending already have the penalties, charges in it, and we are not amending that. It still stands in the Parent Act. So there's no need in repeating clause 2 or in the new amendment again. Thank you.
Amendment is for your consideration. Actually, they are to delete that paragraph. Yes. Any condition?
Thank you very much, Speaker. So, Speaker, in seconding the motion to amend, I just want some more clarification from the motion. A clarification that I think also applies to the way that we have treated clause 1. So, Speaker, mens rea, a very consideration in the definition of criminal offenses. Mens rea. Now, a motor accident occurs. A truck driver is driving. People on board and disembarking, getting on board and disembarking. So, Speaker, have we adverted our mind to whether or not the crime is committed, or we are
principle of mens rea, and the law can also say that there shall be strict liability. What do you say?
Coming to strict liability.
So, but the presumption is a presumption of strict liability.
I beg your pardon, Mr. Speaker.
Strict liability. When you address your mind to mens rea, then you address your mind to strict liability, because the law has the liberty,
yes,
to shift the burden.
That is, and I agree with you, Mr. Speaker, yes, that we could take a position that strict liability occurs. But in a situation like this, even when we decide that we are going to punish strictly, whether you knew of it or not, we as a house need to be mindful of that traffic or people get on board vehicles. And I thought about it. Say a truck driver he doesn't know on board who is not getting on board. A pregnant woman gets on board. And we want to say that if anything fetus of a pregnant woman on board, if there's an accident, that he is strictly punished. I don't know if it's something that we have consciously thought through this provision of strict liability.
Yes, no.
Speaker, first of all, this is a traffic offense, and some traffic offenses don't require press proof of intention. Mens rea. In fact, where it is that the driver of a vehicle drove recklessly, that is additional to the liability. That aggravates the punishment. So mens rea is not really a concern in this matter. Now, but the worry is because it's a traffic offense. When you look at clause 1C, there's no option of a fine. That's my worry. It's a traffic offense. The person drove recklessly. Even though he did not intend to cause an accident, the manner and nature of his driving caused the accident. Do we send him to jail? And the accident results in the loss of an unborn child. A fetus. Do we send him to jail? I think, or do we fine him? Or do we provide the option of a fine so that if they fine and then the judge exercises the option of him to jail? So I think, Mr. Speaker, and it's a standard provision in our criminal law in this country, that where the punishment is defined in terms of years, there's a corresponding fine. And so I'm craving your indulgence to introduce the fine. Because if not, it will be too onerous. Too onerous.
Yes, you want to protect.
Can you imagine, Mr. Speaker, your driver is taking you, is using the sari. A woman out of haste crosses the road. Your driver did not intend to cause an accident. He warned the road users. But the woman crossed the road all the same. Your driver knocked the woman down.
You know the definition of.
They will not give the option of a fine,
Yes.
because he didn't set out to cause an accident. In fact, there is even contributory negligence, because the woman failed to. I'm saying contributory negligence.
Yes. On our second Deputy Speaker.
Mr. Speaker, just to advise my colleague that it's improper to try to draw the Speaker into the arena of conflict. You could have mentioned another person than trying to rope in the impartial arbiter. It is true that just to restrict the law to only imprisonment is unfair. We should have the possibility of a fine. But the stand in this matter is not that the driver drove recklessly. No. It's that the driver drove without due care and attention. That is different from reckless. It is without due care and attention. And that one, I agree that there should be an option for a fine, not just only imprisonment. If it's established beyond the standard of attention to that of recklessness, then there is a higher sentence because of the use of reckless. And so the two say.
Honourable Second Deputy Speaker, please, what kind of fine will you? No, I want, if the Second Deputy Speaker can help with.
Mr. Speaker, we have already passed legislation in this matter. There is a standard. There is a standard for calculating the fine in correspondence to the term of imprisonment. So it is stated that if it's 3 years, the fine should be that. We've already passed a law on that.
We leave that to the draft person.
Yes, so we leave that to the draft person.
All right. Thank you.
Fine.
Further help. The original law has this in it. 31. A person who rides a cycle dangerously on a road commits an offense, blah, blah, blah. And he says that, and his summary comes to a fine not exceeding 250 penalty units or a term of imprisonment not exceeding 12 months. The fine regime is there already. So we could just apply the fine regime, the prison terms that the chairman proposed. So to make it simpler, so the draftsman can take it on board, use what's in the original bill.
Yes, Mr. Speaker, I agree that there's a sanctions regime for dangerous riding. But when a fetus dies, we move to another realm. So the sentence as proposed in this amendment is okay. Have the corresponding fine, which the draft person, Mr. Speaker, I'm sure, will be able to do that. Thank you.
Very well. The amendment is drawn there. Save that the appropriate penalty should be decided upon by the draft person in line with what is existing. So there will be a proportionate increase. Is that so? That means so. I order so accordingly. Yes, Chairman.
Hello. Thank you, Honourable Speaker. Amendment proposed. Clause 3. Amendment proposed Section 6, line 1, delete motto and do see wherever motto appears in the clause. Line 2, before insert injury, or before death insert injury, or any line 3 and insert a person. I shall move.
Honourable, for your consideration. Yes, Honourable.
Mr. Speaker, I support the proposed amendment, specifically in line 2, where we are deleting driver and inserting a person in charge, because we are talking about clean and then driving here. So it makes it to use the word in charge of or in charge of a vehicle. Thank you, Mr. Speaker.
Thank you very much. Any further consideration? Subject, put a question. All those in favor of the proposed amendment say aye. Those against say no. The ayes have it. Long title. And the question is that clause 3 as amended to stand part of the bill, and all those who say aye.
Thank you, Honourable Speaker. Non-title, Speaker. Amendment proposed. Delete and insert as advertised.
Delete and insert. Yes, Honourable Majority Leader.
Mr. Speaker, the long title relates to the prescription of acts that constitute dangerous driving. That results is plural. Acts. So you should rather read that results, not that results. And then in line 4, the same thing. We delete results and rather insert results, because it's plural. So it will read an act to amend Road Traffic Act 2004 at 6A3 to prescribe acts that constitute dangerous driving that result in the injury or death of an unborn baby. So we are going to have then consequentially to amend that one or dangerous cycling that results. So that the two amendments. So the fetus in unborn baby, and then results we change to results. As we move, Mr. Speaker.
Mr. Speaker, once again, we are amending the Road Traffic Act. Now, the Road Traffic Act makes a distinction between where dangerous driving leads to injury and where dangerous driving leads to death. There is no option of fine where dangerous driving leads to death. Now, the debate is whether or not we are equating the death of a fetus to the death of a human being. If we are, it is clause 1C of the Road Traffic Act that we are amending. That will be the appropriate amendment. And if we take that the fetus's life needs to be protected human being's life, then this whole debate about a fine doesn't come in, because in the Parent Act treat life in such a way that we give an option of a fine if it is lost as a result of dangerous driving. It's clear in terms of our mind what we want to achieve. Yes, I led the argument because if you recall, I kept asking you for the act. I said, what are we amending? Let's go to the Parent Act and see how does the Parent Act treat the issue. But even the mover, the sponsor of have the act. He didn't have the act. You have to go out and get us the act. He's not the only sponsor. There are 4 sponsors. You have the electronic act. You have the electronic version. Mr. Speaker, I think the issue is that let's be careful what we actually want to do. Do we want the fetus the way we protect every other human being? Yes. In which case, we have to go back to C, which says that if death occurs, the imprisonment should be a term of not less than 3 years. That's what it says. But then how do we equate the fetus to the human being and treat them the same way in the passage of this legislation, and then insist on strict liability? I have always held the position. That yes, we want to progressively introduce people for fetuses, but we shouldn't give the same level of protection. And that's why I support the amendment. And lastly, Mr. Speaker, that we are proceeding without rescinding your earlier vote on clause 1 of the bill, because it is in clause 1 of the bill that spelled out the penalty. So it is in clause 2 that we raise the issue, and then we amended. We need to correspondingly amend clause 1. Then Mr. Speaker has to rescind the decision, the vote that was taken on clause 1
accordingly. That was what the honourable leader proposed. Yes, Honourable Husseini.
The consequential amendments. There are consequential amendments in the head notes. There are consequential amendments in
clause 1,
clause 2, and clause 1 too. I just wanted to remind that the draft will be directed to consequential amendments.
Very well. And all consequential amendments to follow accordingly. Honourable Husseini, and all consequential amendments to follow accordingly. Then you are okay. Very well. All those in favor say aye. Against say no. The ayes have it. And the long title as amended stand part of the bill. And all those in favor say aye. Those against say no. They have it. And consequential amendments to follow accordingly. Chairman of the committee, any further amendment? I take it that that brings anything further. Does that bring us to the end of the consideration stage?
There's no amendment, Mr. Speaker.
That brings us to the end of the consideration stage. Honourable members, item listed 16, motion.
Mr. Speaker, I beg to move that notwithstanding the provisions of Standing Order 131 sub 1, which require that when a bill has passed through the preparation stage, the third reading thereof shall not be taken until 4 hours have elapsed. The motion for the third reading of the Road Traffic Amendment Bill 2020 may be moved today. I so move.
Yes.
Mr. Speaker, I second the motion.
Thank you very much. All those in favor say aye. Those against say no. The ayes have it. Motion listed 17.
Mr. Speaker, I beg to move that the Road Traffic Amendment 20 be now read the third time. I so move.
Thank you. Who said Honourable Mubarak?
I second the motion.
Thank you. All those in favor say aye. Those against say no. The ayes.
An act to amend the Road Traffic Act 2004, Act 683, to prescribe acts that constitute dangerous driving that result in the injury or death of a fetus, danger or dangerous cycling, the injury or death of a fetus, and for related matters.
The Road Amendment Bill 2020 is duly read the third time and passed. Honorable members, thank you very much for your hard work and for working towards the passage of a private member's bill. I must appreciate the work of the leadership, the majority leader and the minority leader in this direction, as well as the newly established legal department, particularly Lawyer Sina of the legal department, Madam Ofuri Boating, and all our collaborators from the Attorney General's Department. And I trust that this will encourage members to interrogate the law and, for that matter, help in developing some gaps that are in our laws, especially those that affect human rights. Thank you very much. Honorable Majority Leader.
The Speaker, I believe we can now attend to item number 18. 1-8.
Item 18. The first Deputy Speaker will please take the chair. Item 18. We'll go back to the consideration stage, please. Item list 13. National Blood Service Bill 2020 at the consideration. Is the chairman available? Chairman. Chairman, where are we?
This part.
Thank you, Mr. Speaker.
I will tackle the first three clauses. We are on clause 4?
Yes, clause 4.
Clause 4.
Mr. Speaker, clause 4. Amendment proposed. Paragraph K. In lines 1 and 2. After banks, we are to insert blood banks, so that the new rendition will read: inspect and accredit first blood banks and blood banks before the hospital blood banks and blood banks can be supplied with blood and blood by the service.
Thank you very much. That clarifies it. Honorable members, the poll for consideration. All those in favor say aye. Those against say no. And the question is that clause 4 as amended, stand part of the bill. All those in favor say aye. Those against say no. Clause 4 as amended, stand part of the bill. Clause 5. Honorable Chairman, 5, 6, 7 to 16 be dealt with. Clause 5 to 16 have they been dealt with?
Mr. Speaker, we already dealt with. We dealt up to clause 22. Yes, but there was an outstanding one in clause 17.
Clause 17.
We want to take it now before we move to clause 27.
And then move to 27.
Yes.
Very well. Clause 17.
Mr. Speaker, clause 17, amendment proposed, sub-clause 7, delete the whole sub-clause and insert the following. The proceedings of the Blood Service Technical Advisory Committee shall not be invalidated reason of a vacancy among the members or effect in appointment or qualification of a member. This is the standard rendition, so we want to.
Yes, very much. Honorable Husseini.
We had used the formulation in clause 8.7. So we are just repeating the same provision clause 8.7. Thank you.
Thank you very much. All those in favor say aye. They say no. The ayes have it. And the question that clause 17 as amended should stand part of the bill. All those in favor say aye. Those against say no. The ayes have it. Now we move on to clause 27. Clause 20. Chairman, are we in 20 or 27? Where are we next? 23. Clause 23.
Internal unit.
There's amendment. What about 24?
Funds of
25.
bank accounts.
6.
Expenses of the service.
I know advertisements regard to all these clauses, and I'll put a question. All those in favor say aye. Those against say no. The ayes have it. And the question is that these clauses should stand part of the bill, and all those in favor say aye. Those against say no. The ayes have it. Clause 27.
Accounts and audit.
Chairman.
Mr. Speaker, clause 27, amendment proposed, sub-clause 1 and 2, delete and insert the following. So sub-clause 1 and 2 will go to inserted. 1. The board shall keep books of accounts, records, returns, and other events relevant to the accounts in the form approved by the Auditor General. And the board shall submit accounts of the service to the Auditor General for audit within after the end of the financial year.
Honourable members, the proposed amendment is for your consideration.
Yes, Chairman. I have to put the question on 27, right? Clause 27. All in favor of clause 27 being a part of the bill, say aye. All like the ayes have it. Clause 27 stand part of the bill.
Mr. Speaker,
yes, Chairman.
I moved to amend in 27. So we have to.
Have you? I thought you had moved both amendments. So
yes.
I'm putting the question on the entire 27.
Yeah, but the Speaker didn't put the question for the amendments to be carried. The 27.
Item III.
Yes.
Very well. Members, all in favor of the proposed amendment say aye.
Aye.
All against say no. The ayes have it. The amendment is carried. 27 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 27 as amended is ordered to stand bill. Clause 28.
Annual reports and other reports.
The Speaker, 28. Amendment proposed. Subclause 1. Delete subclause 1 and insert the following. The board shall, within 30 days of the receipt of the audit report, submit an annual report to the minister covering the activities and the operations of the service for the year to which the report relates.
The proposed amendment is for the consideration of the House. All in favor of the amendment? All against say no. The ayes have it. The amendment is carried. Item V.
The Speaker, clause 28. Amendments. Subclause 4. Line 1. 4 submit. Set also, and in line 2 delete request. Set require.
Yes. All in favor of the proposed amendment say aye. All against say no. The amendment is carried. Now, clause 28 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 28 as amended is ordered to stand part of the bill. Clause 29.
Recruitment of blood donors.
Item VI.
Clause 29 amendment proposed. Subclause 2. Delete and insert the following. Despite subsection 1, service may A. outsource to a non-profit making of the education and recruitment of blood donors, or B. authorize an institution or collaborate with an institution to educate and recruit blood donors.
All in favor of the proposal say aye. Yes, Honorable Leader. The Speaker, not telling us why he wants to change the original rendition to do this. Why? Why do you think you should replace the original rendition with this? Yes, Chairman. You want to hear why substituting it?
The reasons were first because blood donation is quite challenging, to widen the scope with which the service will be able to engage more interested parties to maximize the number of bloods that can be secured to support their operations. And the second one was to tidy the rendition in the original bill.
Yes. Mr. Speaker, if you look at the original rendition, it talks about, for example, the two. Despite one, the service may, with the approval of the board and under the supervision of the chief executive officer, a non-profit making organization, the education and recruitment of blood donors. If you look at the proposed amendment, it is not mentioning the board, it does not may. It talks about the service may, and then continue about outsourcing education and recruitment of blood donors, and also authorize an institution or collaborate with another institution to educate and recruit blood donors. The Speaker, yes, maybe the B may be the new, but in that rendition, I think that it is providing more safeguards as to who and who can and how it can be done than the way the amendment is being proposed. So that's why I was asking that the amendment taking care of the original rendition doesn't tell us what it wants to cure. The original rendition, in my view, is putting more safeguard than the way the amendment is being proposed. So that's why the chairman must come clean. Yes, Chairman, have you asked the board
Mr. Speaker, the service also includes the board. And if you look at the function of the service, the main authority is the board. So they give direction to the service, the management to offer whatever they do. So by using the service, it is implied that the approval will obviously come from the top. Because that's why we didn't mention the chief executive, but we said the service. Before what the chief executive implements anything, they have already approved it in their deliberation before it is done.
That's an interpretation which may be abused. So it is safer. Yes, Chief.
Speaker, my suggestion to the chairman would be to keep the 29 to and try to amend to just add the B part of his amendment. The B part where it's talking about collaboration with other institutions, because in the A you do not see it come out clearly when it says despite such the service may with the approval of the board under the supervision of the chief executive outsource the non-profit making organization the education and recruitment of blood donors. It seems to have excluded other institutions because the others include institutions that are doing it for profit. When you talk about the B, my understanding is that some institutions may profit, but they can collaborate with them just to enhance blood donation and what do you call it, blood donor education and what have you. But they may be profit-making organizations. The original rendition is it to stick to only non-profit making organization. If you look at the B, that is, it may include institutions that may be profit making. And if he strongly feels about the B, he could amend to that, to the original rendition, than to just take the original rendition away from the decision of the chief executive. I mean, Speaker, you've been chief executive before, and you've heard a number of times how boards and board chairs will want to virtually elbow in some of these decisions. I think the original rendition is neater than the way the amendment is being proposed. So maybe think about it.
Yes, leader.
Mr. Speaker, I believe the value really is the same if we don't include the board, because this really, education and recruitment, is with the service. It's the recruitment aspect that I'm worried about. But the education, really, if you the objects of the service, the object of the service, the object of the service to provide safe and adequate blood and blood products to patients who require blood transfusion therapy care institution and a private healthcare institution. So that's the object. Now, what's the role of the chief executive? The chief executive's position, the Speaker, is covered under and in 18.3, the chief executive officer is the head of the service. So when you say that the service is going to do this, necessarily the chief executive. So as far as I'm concerned, the chief executive is already involved. The other one has to do with the employment, and that's the recruitment of blood donors. Should it be a function of the board? I'm not too sure that the functions of the board includes recruiting donors, because the governing body are defined under what is it? The functions of the government. It doesn't really include the functions of the board are established under 4. And that is why they decided then to remove the governing body. But the chief executive, as the head of the service, necessarily must be involved in the items covered under 2. So I think that no offense is committed if it's constructed the way they have done it now.
Yes, Chief.
So let me talk about this. Mr. Speaker, leader makes reference to the 18, the chief executive as the head of the service. This amendment also then says that as the head of the service should go ahead to do that without the board. What it means, if we go by, that means he could go ahead to do all these things without the involvement of the board. Well, if you look at the original rendition, it wants the board and the chief executive to play a role. But the amendment, even if we go by your suggestion that since the chief executive is the head of the service, it means that this cannot be behind the chief executive. But then it will mean that it could be done behind the board. Look at the original rendition. It envisages that these decisions should be together with the board.
Let's resolve this and move on. I don't think if we intend a role to play, there's absolutely nothing wrong with adding the board.
Mr. Speaker, respectfully, we are not talking about employment. That really will require the intervention of the board. But this is canvassing for blood donors. I'm sure that this is a function of the board. That necessarily must involve the board. It's a service.
The outsourcing is outsourced to a non-profit making organization, the education and recruitment of blood donors. That is A. And that used to be, that was the original clause 29.
Speaker, the outsourcing,
yes.
Speaker, leader, it could end up being one of the big programs that the what do you call it, the blood service will be having. No, the outsourcing, because here we are talking about the outsourcing of both, if you take this amendment, both the non-profit and possible profit institutions. No, but the B is talking about authorized an institution. So these institutions is not limited to only non-profit. They're not limited to only non-profit. And when you look at how others have done it in other jurisdictions, it's a big thing that the board needs to know. We can go and encumber the resources of the organization, and a lot of other things of the organization because of this agreement in outsourcing. And you cannot leave the board. So I don't see adding the board what it will take away from you.
Mr. Speaker, can we maybe further the subsection 2 to say, despite subsection 1, the service may, under the
with the approval of the board.
May with the approval of,
yes,
and then continue.
Yes. All in favor of both amendments say aye.
Aye.
All against say no. The ayes have it. The amendment is carried. Now, clause 29 as amended. Shall stand of the bill. All in favor say aye.
Aye.
All against say no. The ayes have it. Clause 29 as amended is ordered to stand part of the bill. The proposed new clause after clause 20. Chairman.
Mr. Speaker, new clause amendment proposed. Add the following new clause after clause 29. The head notes, collaboration with other institutions. The service shall collaborate with other institutions in the performance of functions under this act.
Yes, leader.
Well, Speaker, I supplement, but the word other, whether he won't want to substitute it with relevant institution. The service shall collaborate with or added relevant institutions in the performance of its functions. Thank you.
Which one did you suggest we should change? Functions and added.
The service shall collaborate with other institutions. He said we should replace other with relevant. The service shall collaborate with relevant institutions in the performance of functions and
other relevant institutions. Other relevant institutions. That's what I wrote there.
Okay. Other. Okay. So, Mr. Speaker, the new rendition should be: the service shall collaborate with other relevant institutions, performance of functions under this act. Yeah.
Yes.
Very well. All in favor of the amendment say aye. All against say no. The ayes have it. The amendment is carried. Now the proposal clause shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. The proposal clause shall stand part of the bill. Clause 30.
Offences and penalties.
Item IX.
Mr. Speaker, clause 30, amendment proposed, sub-clause 1, paragraph, line 2, at the end, add without option from the service.
Honourable members, in favour of the proposed amendment say aye.
30.
Against say no. The ayes have it. The amendment is carried. X.
Mr. Speaker, clause 30, amendment proposed, sub-clause 2.
Mr. Speaker.
Yes.
Unfortunately, the 30B that he took, I know you were at consideration, if you permit me, where he talks about manufactures or produce blood product for transfusion purposes, and said without authorization from the service. So that he knows that these products, they get license from FDB to do that. When you do that, you are going to add to the cumbersome nature of manufacturing, because FDB has been taxed by law to do those things, and that's why I believe in the original edition it was not added so. So if you add this, what it simply means is that to do anything, to produce any blood product, you have FDB, and you have to also see the blood service to be able to do that. To the cumbersome way of doing business.
Mr. Speaker, the blood products here refers to various components of blood. Fresh frozen plasma, hemocell, they are all just like blood, but they are not whole blood. But since we are establishing, we didn't have.
Honorable, let's look at the definition. Blood product.
Yes.
Means any therapeutic product derived from human blood or plasma.
Yes.
So is it different from what is manufactured and licensed by the FDA?
Mr. Speaker, until the passage of this, we are now going to have an established blood service, and we think that anything related to blood, they should have the power to be supervising it, because they will have the expertise and everything. Once this law will be a newer law than the FDA, they will now take charge and 30.
Yes, honourable member for the group.
Currently,
we don't have this law in operation. We are making a nice how blood is, our blood products are produced and distributed in this country. Even if there's an existing law or an existing provision which makes FDB play a role in terms of certification or whatever, this law should be the new law, superseded. Then we need to look at what to do. Mr. Speaker, it would be wrong for us to spend time to do this and get that entity somewhere that can actually authorize and or give something else about blood. Then this law will not be tight enough. So maybe we need to consider whether what the Chief Whip is saying, we need to ask those organizations who are doing what he's doing now. But I agree that that should be spelled out in this law. It should be this law that allows you to produce and distribute blood products. I 100% agree with the chairman.
Yes, Honorable Majority Leader.
Mr. Speaker, I was just looking at the construct of 31A. 31A. It says, who collects blood or blood products or holds out to collect blood or blood products from a member of the public for transfusion, authorization from the service. Mr. Speaker, I think that the Minority Chief Whip is saying that we need to delete without authorization from the service in 1A, because 1B is special to 1A. Yes, so if it's yes, then we agree that that qualifier should be there. Other than that, you have and delete without authorization from the service. Then that is not what you intend.
Yes, Mr. Speaker, the 1A, in my view, is different from 1B. Because 1B is talking about manufacturing. You see, manufactures or produce. That's different. Handling the product. Because, Mr. Speaker, if you are not careful, then Pharmacy Council will say, oh, when it comes to medication, let them see us. Then Allied Health will say, oh, we handle syringes and others. Let us handle that. And we are saying that that's why FDA, I keep saying FDB. If you look at FDA, its mandate is to make sure that all, what we call it, food and drugs, and they have the necessary laboratory to authorize its manufacturing. They are pointing to 32 for me, that paragraph C. It's talking about C, not B. Yes. Paragraph C, subsection 1, does not apply to blood products approved by sale by the Food and Drugs Authority. But C is, because C is talking about provide for the purpose of transfusion blood or blood product which have not been supplied to that by the service. Mr. Speaker, you see that even this then affirm the reason why I'm saying you shouldn't qualify the B. Because even the bill in C recognizes that FDA has a role that is playing. And if you qualify the B, what will mean that a manufacturer, you have to go to these two institutions to get license. And that could be problematic. Currently, Mr. Speaker, we already have a problem between Standard Authority and FDA.
Mr. Speaker, with respect, I would disagree with the minority with the Honorable Muntaka. Now read 30 the whole. Offenses and penalties. A person who collects blood or blood put, it ends with without authorization from the service commits an offense. So what the chairman is seeking to do in 31B is to say that a person who manufactures or produces blood products for transfusion purposes without authorization from the service commits an offense. So it is elegant and good enough to fly. You have to read it together. No, but you are creating an offense and penalty. So you are saying that should somebody manufacture produce or transfuse blood. Yes, you can do, but if you are doing it, have authorization. That's all that the chairman is seeking to do. That when we come to 32, your concern is addressed. Does not apply to blood products. My view is that I'm not convinced by your argument. Honorable Nusahi did more than drafting. It's not about it's about.
You cannot manufacture or produce blood products for transfusion. For transfusion, if you are going to do transfusion, you cannot, even if you are from the FD, you must get approval for transfusion. You cannot, because if you sell set and they transfuse, they insert the needles and pump the tint into you, it will be an offense. It will be an offense. But FDA can license anybody to blood products that you will swallow. But transfusion, you cannot do it. It must be with order. You cannot do it.
Very well. So, open with the amendment. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item
X. Mr. Speaker.
X is what we did. Insert food.
Oh, we just did IX.
Oh, all right.
So we are now on X.
X, very well.
X, amendment proposed, clause 30, subclause 2, line, delete blood and insert plasma medicinal, and in line 2, delete foods and insert food. So the new rendition will be paragraph C of subsection 1 does not apply to plasma medicinal products approved for sale by the Food and Drugs Authority. So that is what
of the proposed amendment, say aye. I'll put in again. All in favor of the proposed amendment, say aye. Against, say no. The ayes have it. The amendment is carried. Item XI.
Mr. Speaker, clause 30, amendment to clause 3. Opening phrase, line 1 and 2. Delete medical practitioner who, and insert health professional who collects or provides, so that the new rendition will be paragraph A and C of subsection 1 does not apply to a health professional who collects or provides.
All in favor of the proposed amendment, say aye. All against, say no. The amendment is carried. Item XII.
Mr. Speaker, clause 30, amendment proposed, subclause 3, paragraph A, line 1, delete collects, and in line 3, delete medical practitioner and insert health professional. Consequential.
Yeah, Honorable.
Mr. Speaker, I can see medical practitioner and bringing health professional. We have described a medical practitioner, and you haven't described who a health professional is in the interpretation. You intend to do that? Because in the interpretation, I can see medical practitioner described, but not health professional. So why are you
Mr. Speaker, there's an amendment to define who a health professional under clause 32.
Very well. So I'll put a question. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item XIII.
Mr. Speaker, clause 30, amendment proposed.
Sorry, Honorable Chairman, sorry.
Yeah, I would want to draw the Chairman's attention to subclause 3 of 30, the A. Last amendment was to delete collect. But if you read the entire sentence from the 3, it would read, do not apply to a medical practitioner who blood for transfusion for a patient. And I think something is omitted. So, if you could, the amendment that the collect must be deleted. So, if you do away with the collect, then the sentence, there's something wrong with it.
Mr. Speaker,
yes.
Earlier amendment that was done in XI, we said instead health professional who collects or provides. So before now, so then if you don't take away the collect from the A, it will be a repetition.
So item XIII, you may move it now.
Mr. Clause 30, amendment proposal clause 3, B, line 1, it collects, just like consequential, yes.
All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. 30, as variously amended, shall stand part of the bill. All in favor, say aye. All against, say no. The ayes have it. Clause 30, as variously amended, is ordered to stand part of the bill. Clause 31.
Regulations.
Item XIV. Chairman.
Mr. Speaker, clause 31, amendment proposed. We add the following new paragraph. Provide for the safe transportation of blood and blood products.
All in favor of the proposed amendment, say aye. And say no. The ayes have it. The amendment is carried. Item XB.
Mr. Speaker, clause 31, amendment proposed. Paragraph C, line 2. After banks in the paragraph C, wherever banks occur, we insert and blood banks. So then, hospital and blood banks. We have defined hospital blood bank and also blood bank. So we are referring to both hospital blood bank and blood bank. No, we didn't. Leader wanted to put it because blood bank has also been defined in the interpretation.
So blood bank says a term of art.
Yes.
In favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item XVI.
Tobo. Mr. Speaker, clause 31, amendment proposed, paragraph E, line 1, after effective insert and F.
All in favor of the proposal and say aye. All against say no. The ayes have it. The amendment is carried. Now clause 31 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 31 as amended is ordered to stand part of the bill. Clause 32.
Interpretation.
Yes, leader.
Mr. Speaker, I will beg for your leave and indulgence. The Honorable K.T. Hammond was engaging me on some national issues at your back. Mr. Speaker, I know you have put the question, but just to strengthen it, where the minister may, on the recommendations of the board, by instrument make regulations, the B, we have to prescribe acceptable medical standards for the transfusion of blood. Those words there. We can't leave it as open as it is. Prescribable medical standards for the transfusion of blood. Then we have imposed a burden on them. Not any standard for transfusion of blood, but medically. Thank you. If I have your need.
Yes, Honorable Minister of Education.
Mr. Speaker, I want to draw the House's attention to the fact that we have only one standards organization in the country. Only one. The Standards Authority. Okay. Everything, every standard, even including medical. The Food and Drug Authority got their regulatory powers out of Standards Authority. Nuclear, every regulator gets it in every country on Standards Authority. And they prescribe standards for everything all over the world. They prescribe standards for everything. And when you form a regulator like the NCA, like the NPA, like food, then you take the standards of that is applicable in your country, because there might be 2 or 3 different standards. So even though I agree double medical standard, we have to note that the blood transfusion service itself should not start getting their own standards. It has to be relatively something that we use around the world. I'll just draw your attention to.
Yes.
The standards here are administrative standards. The standards at Food and Drug Board are quality standards, nationally acceptable standards. So they're the 2 different things. So I agree with Leader's amendment, acceptable medical standards. Because these standards, what standards? And that's where the question will come in.
Yes, Chairman.
No, I'll stand.
Very well. All in favor of the proposed amendment say aye.
Aye.
All against say no. The ayes have it. The amendment is carried. Now put the question on clause 31 again. And the question is, clause 31 shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 31 as amended is ordered to stand part of the bill. Clause 32.
Interpretation.
Yes, Chairman. Item FVI.
Mr. Speaker, clause 32 amendment proposed. Interpretation of medical practitioner should be deleted.
Yes.
All in favor of the proposed amendment say aye. Aye. Against say no. The ayes have it. The amendment is carried. Item XVIII.
Mr. Speaker, clause 32 amendment proposed. Interpretation of voluntary non-remunerated blood donor, line 1. Delete non-remunerated and insert unpaid.
That is consequential. It's consequential with delays.
All in favor of the proposed amendment, aye. All against say no. The ayes have it. The amendment is carried.
Mr. Speaker,
Item X.
we add the following new definition. Blood bank means a facility equipped to store and distribute blood.
All in favor of the proposed amendment say aye. Aye. All against say no. The ayes have it. The amendment is carried. Item.
The Speaker, amendment add the following new definition. Health professional means a person who is registered under the Health Professional Regulatory Bodies Act, Act 2013, Act 857.
All in yes.
Mr. Speaker, I will support it, but because of the speed with which we are working, ideally one would have wished to refer to 57 and see what the definition of health professional is. So even as you put the question, you can direct the draft people with respect to it for emphasis. Health professional as defined is because of the speed with which we are doing, we can't make cross-referencing. So it should be health professional as defined in it. If you can help me, that would be appreciated.
The definition here provided is a person who is registered under the health regulatory body. So it doesn't provide a definition. If you're registered here, you qualify as a health professional. That's right. All in favor of the proposal? Yes, Honorable Minister for Education.
Mr. Speaker, they have provided some definitions that are very, very inadequate. The two definitions I want to draw your mind is the hospital blood bank definition and the blood bank definition you have given. Mr. Speaker, if you read the hospital blood bank, it means a facility with hospital-related activities which is equipped to store and dispense blood and blood products and perform clinical transfusion-related functions. What are they? What are they? What are they? So, if you insist, we should leave it. But I find it very inadequate. But I'll leave it for now. I'm drawing your attention. Maybe before we get to the third reading, confer with other authorities if you cannot improve it. But I'll leave it for now. I'm just drawing your back. And you didn't even cater for private blood bank. Okay.
Let me finish the health professionals, and I'll give all in favor of the proposed amendment in item XX. Say aye. Aye. All against say no. The ayes have it. The amendment is carried. Now, Chairman, there is the issue with your blood bank.
Mr. Speaker, we were guided by the professionals. So just like Nisa indicated, if maybe we can chance to confer the CEO of the blood service as it exists is around so that we can.
Yes, leader.
This figure is important. If you look at the definition of hospital blood bank, it means a facility with hospital-related activities. Of course, that relates to what the hospital is required to do, which is equipped and staffed to store and dispense blood and blood products. So, in the definition of the blood bank, necessarily we have to include the aspect of the relevant staffing, so that it will read, it means a facility equipped and staffed and appropriately staffed to store and distribute blood, because the staffing is also an essential component of the blood bank. Because the hospital facility requires that storage and the staffing who are, who have the competence to deal with it. So the staffing is also important. So blood bank should mean a facility equipped and staffed to store and distribute blood. Maybe we can also add the blood and blood products. So, equipped and staffed to store and distribute blood and blood products.
Yes.
Just before the chairman proposes anything, Mr. Speaker, in May, we just say hematology department. It's only in Ghana that we still do blood bank, because it's about hematology, it's about blood. And the things, if you see the definition of hematologist service and compare that with blood center and other things, it's all about blood. It's just that one is in a hospital situation and others. So, Mr. Speaker, I think the professional should help us harmonize these three definitions. I think it's all over the place.
Yes, Chairman. What did you bring back from? What did you bring back from the consultation?
Yes, Mr. Speaker.
Good tidings.
The amendment proposed, we, majority indicated, we want to move blood bank means a facility equipped and to store and distribute blood and blood products. Mr. Speaker, the reason for okay.
In favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Now, the clause 33. Sorry.
Transitional provisions.
1 moment. I have to put clause 32. And the question is clause 32 as amended. Shall stand as part of the bill. All in favor, say aye. All against, say no. The ayes have it. Clause 32 as amended is ordered to stand part of the bill. Clause 33.
Transitional provisions.
There's no advertised amendment to 33. Yes, Honorable Manatli.
Speaker, just one, and the assets and liabilities. Why the word accrued? Is assets and liabilities in respect of or in relation to property? You don't need the word accrued there. My strong view, the word accrued. And then 2, staff. Did you have staff? Why are you protecting only assets and liabilities? Are there any staff that we need to, but to satisfy myself? Where? Because the 30, I shall read it. My bill, the 3 is missing in the next 2 pages. Okay, yes, so. Okay, Mr. Speaker, I'm satisfied I've received this page. I was misled by the emptiness of the page. But the word accrued, I have difficulty with it being included. Thank you. Accrued, delete it.
In which clause or subclause? Yes. Honourable Member for the group.
Mr. Speaker, forgive me. Can the chairman show me where the definition immunohematology was used in the bill? You use the word you are defining immunohematology service. Where did you use it in the bill?
Hematology service, immunohematological service. Very well. I'll go to the long titles. You're looking for that. If you can't find it, you may decide whether we want to keep it there. The long title.
An act to establish the National Blood Service and to provide for related matters.
It's a shuffled part of the bill. All in favor say aye. All against say no. The ayes have it. The long title is ordered to stand part of the bill. Chairman, did you find where you used If you can't find it, let's just read from the interpretation session. Yes, ranking member.
It's used actually in the definition. The definition of blood center. Yes, blood center interpretation. And then means a facility equipped and staffed for the collection, testing, processing, storage, and distribution of blood products and other immunohematological hematological services. Yes, that's the only place that it has been used. That's where it has been used.
Yes, Chairman.
Yes, Speaker, just like it was used to interpret define blood center, and since it's a term of, I wanted to also define that so that it doesn't state any ambiguity.
I don't think it's not part of the bill. It's not part of the bill, so we don't have to interpret it.
Mr. Speaker, in the bill, the interpretation part of the bill, the second item interpreted reads a blood center. A blood center means a facility equipped and staffed for the collection, testing, processing, storage, and distribution of blood and blood products and other immunohematological services, but does not include a hospital blood bank.
You're interpreting your interpretation.
Yes, because he has introduced a phrase that does not happen anywhere else. So that is why he's saying he did. That's why he's saying he did.
Very well. I'll leave it with you and your draftspersons. If you decide that it should stay, keep it. Yes.
We accept your guidance accordingly.
Very well. That to the end of. Yes, Honorable.
Mr. Speaker, in the transitional provisions, there is a standard construct. I think I see one missing here. Is monies that may be lodged in some bank accounts. So the draft person should look at that. There's a standard construction. If it's possible to include that. Yes.
Very well. I direct the draft persons to redraft the transitional provisions to reflect the establishing adopted by the House. That brings us to the end of the consideration of the National Blood Service Bill 2020. Yes, Honorable Majority Leader.
Mr. Speaker, with respect, if we can go to other paper, addendum. Present the papers which have been mentioned in the other
They are all Presentation of papers. Very well. Order paper addendum. Presentation of papers. 1 by the Minister for Finance. Yes, Honorable.
Second.
A.
Second addendum to the deferred payments agreement between the Republic of Ghana, represented by the Ministry of Finance and Military Highways, and Sino Hydro Corporation Limited, setting the terms and conditions of the deferral of payment to the EPC contract agreement in respect of construction, rehabilitation of selected roads and interchanges in Ghana, Phase 1, under the Master Project Support Agreement.
The paper is duly late. It's referred to the Committee on Finance to consider and report. Item AII.
Term loan facility agreement between the government of the Republic of, represented by the Ministry of Finance and Standard Chartered Bank London, for an amount of 222,404,176 euros and 25 cents, including Euler Helmet's premium guarantee, to finance the design and construction of Ashaman Runabout, Akosombo Junction, upgrading for Eastern Corridor Road, Lot 1.
The paper is duly late. Is referred to the Committee on Consider and Report. Item III.
Loan facility agreement between the governments of the Republic of Ghana, representing the Ministry of Finance and Standard Chartered Bank London, for an amount of 60,257,921 euros and 13 cents, to finance the design and construction of a Sherman Runabout to Akosombo Junction, round about upgrading of Eastern Corridor Roads, Lot 1.
The paper is presented is referred to the Committee on Finance to consider and report. Item IV.
Facility agreements among the governments of the Republic of Ghana, represented by the Ministry of Finance, Ivestec Bank, South Africa, as agent, global coordinator, and mandated lead arranger, and Intesta Sao Paulo AA Dubai branch, as mandated lead arranger, for an amount of 46,600,000 euros. The construction of Tranche 1 of the Bolgasanga Boko Mankum Road project.
The paper is duly presented. It's referred to the Committee on Finance report. Item V.
Facility among the governments of the Republic of Ghana, represent the Ministry of Finance, Ivestec Bank Limited of South Africa, as global coordinator and mandated lead arranger, and Intesta Sao Paulo SPA Dubai branch, mandated lead arranger, for an amount of 35,400,000 euros to finance the construction of the Bolgatanga Boko Polimankom Road project.
The paper is duly presented. Is referred to the Committee on Transport to consider and report. Item B. I by the Minister for Roads and Highways.
Supplementary Agreement Number 2 to the Engineering, Procurement and Construction EPC Agreement between the Republic of Ghana, represented by the Ministry of Roads and Highways, Sino Hydro Corporation Limited, in respect of the following road projects constituting Phase 1 projects under the Master Project Support MPSA. I. Accra Inner City Roads. II. Kumasi Inner City Roads. III. Tamale Interchange Project. IV. PTC Roundabout Interchange Project, Takrady. V. Adenta Dodowa Dual Carriageway. VI. Tinyani Inner City Road. VII. Western Region and Inner City Roads. VIII, upgrading of selected feeder roads in Ashanti and Western Regions. IX, rehabilitation of Nato of Wasi Road. X, Hohoi Jasikan Dodi Pepesu.
The paper is duly presented is referred to the Committee on Roads and Highways to consider and report. Yes.
Mr. Speaker, the next is item 2. The Deputy Minister for the Deputy Minister will do so for the Minister. 2A.
Very well. 2A. Security and Industry Amendment Bill 2020. By the Minister for Finance.
An act to amend the Securities Industry Act 2016, Act 9 to provide for the conduct of investigation by the Commission when the Commission is assisting domestic or foreign regulatory authorities. The procedure formed with a request for assistance from a foreign securities regulatory authority. The issuance by the Commission of codes, directives, guidelines, and circulars, and for related matters.
The bill is duly presented is referred to the Committee on Finance to consider and report. Item B. Mr.
Speaker, with your indulgence, before I read item 2, to come to order 132 to withdraw the University for Film and Journalism and Languages Bill laid on the 6th of October 2024 and proceed to do that. I want to. No, I'm come to relay.
Very well. Yes, Honorable Minority Leader, I want leave to withdraw an earlier bill. Any comments? Well, leave is granted to withdraw. Right. Now we may proceed of the new.
And access the University of Media, Arts and Communication, and to provide for related matters.
The bill is presented. It is referred to the Commission to consider and report. Yes, Honourable Member for the group.
Mr. Speaker, the Finance Minister, our colleague, the Deputy Finance Minister, a couple of agreements that look like things we've dealt before. At least it will be helpful if he tells us all these garden roads came to this house with them at the Finance and the Roads Committee. So if there's any new campaign, he can give us a background as to why we are seeing them being laid again.
And I remember, look at your Sunday orders. This is a presentation of papers. You can go to the committee and get all the information they want. Very well. That brings us to the end of the proceedings for today. The House is accordingly adjourned. Yes, Leader.
To remind that the of 9 lessons and carols begins in earnest at 5 p.m. prompt, and members are required. As I indicated on at 4:30. So that is before we take the adjournment, so that members will be at 4:30.
Sorry, I didn't get you. What at 4:30?
The Festival of 9 Lessons and Carols. It begins in earnest 5 p.m. Members are required, the staff are required to be seated at 4:30. So just a reminder.
Seated by 4:30.
Right.
I didn't get that. Very well. Yes, Honourable Minority Leader.
Mr. Speaker, I believe the parliamentary service will support for that Thanksgiving service of Carol's night. And to note that I hope that we're not adding new businesses to what we have. I said, I hope you are not adding new business to what you yourself presented and we got approved. We need to go for Christmas and to get some rest, Mr. Speaker. We need rest after this rest. And apart from rest, you are in arrears, members matters, you are not dealing with those welfare issues. Next week, we won't mind the finance people if they don't deal with those whips. Those outstanding issues, if he doesn't deal with them, Mr. Speaker, he won't have our pleasure. That's why it's off record.
Honourable members, the House is adjourned to Monday, 1st of December 2020 at 10 o'clock in the afternoon.